We start off at The Hague. The hearing of a no case to answer for Deputy President William Ruto and journalist Joshua Arap started there at the court today. The two want the court to drop charges of crimes against humanity leveled against them and relating to the post-election violence that followed the 2007 elections. Here's Rita Tinina with the details.
It has been close to 40 days of no activity in the courtrooms, during which the ICC moved to new premises, followed by a recess.
A magistrate who has decided.
Kenya's Deputy President William Ruto and his co-accused Joshua Arap become the first to be tried in the new chambers, their case being the first to be heard in 2016. The Tuesday session began on a good note for Ruto after his lead counsel, Karim Khan, convinced judges to allow evidence to be heard in public despite objections by the prosecution, which argued that a public hearing could endanger witnesses, several of whom withdrew their testimony.
Many witnesses gave evidence with pseudonyms or voice distortion. So there's no reason in principle in our respectful submission why the contents of the evidence shouldn't be transmitted to members of the public.
Ruto, who is facing crimes against humanity charges over the 2007-2008 post-election violence, has filed a no case to answer motion before the court, seeking to have the case against him terminated, arguing that the ICC prosecutor Fatou Bensouda has not proved any charges against him. But on day one of the submissions, prosecution lawyer Anton Steinberg sought to prove that Ruto has a case to answer.
Prosecution, however, intends to take the chamber at its word and to focus not on the credibility, reliability and cogency of the evidence, but rather on whether the quantum of the evidence, if accepted, may establish the guilt of the accused.
The prosecution is convinced that it has enough evidence to secure a conviction against Ruto.
Quantum of evidence. Is that enough?
Your Honours, my submission is yes, it is, unless the quality of the evidence in question, unless the duff outweighs the plums to such an extent that the court will conclude that that witness's evidence is incapable of belief.
The prosecution detailed how the post-election violence was organized and coordinated, giving figures of those injured, killed and displaced.
744 out of 1,133 people killed in Kenya were killed in the Rift Valley.
The court went into brief private sessions as the prosecution sought to link Ruto to the post-election violence.
Firstly, a meeting at Mr. Ruto's Sogoi house on the 20th of October 2007. Secondly, a meeting at Mr. Ruto's house in Sogoi in mid-December 2007.
A status conference in the Ruto-Sang case is scheduled for Friday. But before then, Ruto's legal team will seek to persuade judges that he has no case to answer. The hearing will mark the final push by Ruto to try and convince judges to drop the charges against him. But the prosecution will not be resting easy as it tries to secure a conviction. The ICC has handed down only 2 convictions in the last 13 years. Rita Tinina, KTN News.